Good afternoon, Chair Wilson, Vice Chair Crosby, and members of the committee. My name is Selena Raleigh, and I'm testifying today on behalf of the Maryland Cannabis Administration in support of HB 204, Cannabis Wholesaler License Establishment. This bill is a departmental request from the MCA to establish and define a new wholesale cannabis license category. It will establish fees associated with application and licensure for this category, authorize the administration to award up to 15 wholesale cannabis licenses, and require the administration to incorporate the new category in forthcoming licensure rounds. This framework is largely forward-looking. In 2023, the MCA submitted a predictive modeling report, which will be in my written testimony, to the General Assembly that indicated that early adoption of wholesale licenses could position Maryland as a strategic hub for cannabis distribution in a national market should federal rescheduling occur. Established wholesale distributors in Maryland would be crucial for managing out-of-state product flows and ensuring compliance with Maryland's testing, packaging, and labeling standards. Relevant near use of wholesale licenses could be to support current micro businesses, which are explicitly small social equity businesses, by providing them with centralized safe storage and inventory management, and potentially facilitating partnerships that would reduce cost and increase operational efficiency for micro businesses. Ultimately, the creation of a wholesale license category through HB 204 positions the MCA and the state of Maryland to be better prepared for future interstate commerce, and early establishment will likely provide long-term advantages. For these reasons, the MCA urges the committee for a favorable report. Thank you for your time.
Good job, Selena. Seeing no questions, that concludes this panel. We now have one favorable with amendment. Rusty Carr. You can start when ready, sir.
Thank you, Chair Wilson, Vice Chair Crosby. My name is Rusty Carr. I'm a resident of Mount Airy, District 4, a Maryland medical cannabis patient and a caregiver and an interested citizen and resident of District 4. Guys know about shelf space agreements? There's a lot of tricks that have been going on in the cannabis industry, and there's a lot of tricks that a wholesaler or the industry can pull to give preference to cultivators or preference to dispensaries, either way, to lock one out of the other, to play games with this. The proposed bill asks the Maryland Cannabis Administration to define the regulations of what's allowed and what's not allowed, but there's been things like shelf space agreements that are already in the industry. There's a lot of tricks that can be pulled, and I'd like to see that guidance to the MCA that the rules should be a little bit more specific on what's prohibited and what's allowed when they do that. There are other concerns that I've raised in my written testimony. Questions like, do we want to allow wholesalers to also wholesale for alcohol and cannabis together, or should there be a provision to keep those separate? Questions like that. There's a lot of questions that I have. If you've got questions, I'm here to answer them, but I hope you take my questions and answer them and make a better bill out of this. We're not ready for this. Maybe next year. Thank you. Any questions?
Yes. One question.
Thank you. You alluded to what you, in your terms, trickery, I think you said, as it relates to shelf space. Mm-hmm. Can you be more elaborate on that?
In the early days of the medical cannabis program, there were times when there were shortages of supplies. And what some of the cultivators did was they went to the dispensaries and said, we can guarantee you supplies via a shelf space agreement. But essentially what that does is takes over the dispensary and puts the sales into the cultivator's hands. So it takes out of their margins, and it controls how they do their business. And we've seen several of the medical dispensaries at the lower tiers struggle to make a profit because the cultivators have done that. You can see that in the statistics from MCA or MMCC in the early days, where the wholesale price is 60% of the retail price. Normally, the markup is a little bit more than that on the retail side, and what the wholesalers have done have pressured the dispensaries. And so I'm trying to ask that you guys put some language in the bill to eliminate or restrict the ability of the wholesalers or the cultivators to pressure the dispensaries.
Thank you.
Thank you.
Thank you, sir. We now have unfavorables, Ashley Bagwell and Joe Bryce.
Good afternoon, Mr. Chairman, Mr. Vice Chair, and members of the committee. I'm Ashley Bagwell, here this afternoon on behalf of the Maryland Dispensary Association in opposition to House Bill 204. In 2022, when this committee and the General Assembly passed legislation legalizing cannabis for adult use, in the bill, y'all also included language to require a number of studies of the then MMCC, now the MCA. One of those studies was a study on wholesale licenses. That study has been completed, and one of the findings in that study is that there is no immediate need for this kind of license. Additionally, our primary concern, I think, is that this adds another layer to the system, thereby potentially increasing prices for cannabis. As this committee is well aware, it is incredibly mindful to be cognizant of things that potentially increase the cost of cannabis, because doing so drives people from the legal market to the unregulated illicit market. And for those reasons, Mr. Chairman, we are unfavorable on this bill. Thank you.
Thank you, Mr. Chairman, members of the committee. I'm Joe Bryce, or whoever the chairman called me. I'm here on behalf of the Maryland Wholesale Cannabis Trade Association. We join the Dispensary Association in opposing these bill, largely for the reasons that Ms. Bagwell mentioned. I think the report itself was very well done, very well prepared, and I think there may be a need, if it's ever legalized at the federal level, to have this type of structure. But I don't think it's around the corner, and I think we're going to have to do a lot of other things besides just create a wholesale license category. So I would ask the committee to give it an unfavorable report and come back and look at it when we need it.
Joe, what other things do you think need to be done prior to actually going forward with our wholesale licensing?
Well, I mean, to the extent that it is forward-looking and looking at federal legalization, I think you're going to have all kinds of issues about how those products get tested, about how they move in interstate commerce, who's allowed to move them. I think there's going to be any number of things that come with legalizing and bringing your laws into accordance with what would now be a federally legalized product. So whether it's the banking, the financing, all those things that we can't do now because it's illegal under federal law, I think you'd have to address those to the extent there are gaps in state law.
And I guess the tension that we are living in here is we agree that there are things we need to do, but getting ahead of this, because what we don't want, after we've worked very hard, obviously within the interstate commerce clause, to make sure that in Maryland businesses can grow and are protected. We don't want is obviously to be taken down because of out-of-state, cannabis. And I'll be interested in your solutions as far as this approach, because I think one of the things when we drafted the bill, it was a complex issue, is to make sure that we don't miss whatever that timeline is, that we don't react, that we do it within our planning. And I believe that, MCA did what we had asked them to do as a legislature. So again, I know we're not under the gun, and I don't want to be. So I would be interested in, I guess, offline, you and Ashley, what your suggestions are along with the MCA to make sure if this bill doesn't pass this year, because again, there's no driving need, I'm not even sure if we're going to move forward or regress as far as nationalizing cannabis with this new administration. But would definitely be interested in your input to find out, because again, we have goals. I'm trying to leave here with more of a plan. So thank you very much.
I appreciate that.
Happy to do that.
No questions. That completes this bill. Next bill is House Bill 12.
Thank you. Good afternoon, Mr. Chairman, Mr. Vice Chair, members of the Economic Matters Committee. My name is Jeff Kelly. I get to serve as the Executive Director of the Alcohol, Tobacco, and Cannabis Commission. And I am here today advocating on behalf of HB 12. Thank you very much, Mr. Chairman, for sponsoring the bill for us. Quick walk down memory lane. Many of you may recall from your times in this body, or perhaps just as interested citizens, that for several years ago, we were chasing all sorts of products that were coming out. We'd see it in Ocean City, you'd see it in Baltimore City, products that kind of mimicked what cannabis does. And each year it was in violation of law. The General Assembly had to pass bills to address that. And the bills were kind of wonky in many ways, specifically because what we knew best then was to identify the product as much as possible. And in fact, what would happen was the bill would say this chemical composition is now illegal in the state, and that worked. But the chemists who were interested in furthering that industry would just change the chemical composition the next year and create something new. And in fact, back in 2013, I was just looking for different bills that impacted that. And this 2013 bill, House Bill 482, which was co-sponsored by at least one of you in this room, who foresaw a need to do this, addressed these different compounds and labeling issues surrounding them. And I would like to read some of the bill to you, but I won't, because I can't pronounce almost any of it. This bill didn't pass committee, but it was a great idea. But it's over 3 pages of chemical names that we don't allow in the state, or we didn't want to allow in the state. We wanted to make it illegal. So this was absolutely the right idea, was to try and ban these things, but it didn't work out as a matter of practicality. So what happened is we were year after year chasing these new products that would come out. But it brought us to a place that works. And simply put, you guys got it right. You solved this problem years ago when you passed the Cannabis Reform Act. You honed in on the quantity of the psychoactive element, THC, and didn't care, thank you, and didn't care how it was derived or what its composition was. You said we actually are interested in the quantity of THC that is mind-altering, that's going to make the difference. And that really made the chemical processes, the syntheses, the compositions irrelevant. So that was really a big deal. So kudos and thank you for that. Today, we have a great framework that makes a lot of sense. It generally supports the lawful industry, and it also provides us with pretty clear direction on how to take action against the illicit market, which is our role at the ATCC. All of that notwithstanding the Washington County Circuit Court case, a court injunction on us that stops us from enforcing some elements of our cannabis law currently. But even with that in place, we are still able to do some work, and that is to go to places that weren't licensed before a certain date. And nowhere in the injunction does it say they can sell to kids. And we spend a lot of time on that. So we worked in Worcester County, Queen Anne's County, Baltimore City, maybe Baltimore County, to address some of these issues where they're selling to underage consumers and children. But one of the problems is, while the structure for the enforcement process is great, the efficiency of it is not. Here's the issue. We send an agent into a store or someone who's an underage consumer who's buying for us. They make a purchase of one small little container. We send that container to a lab in Pennsylvania. It takes about 45 days to get testing done and get the results back. And then we issue a citation to the person. All in all, it takes about 2 months for us to remove one small container of a THC product that isn't being sold lawfully. So effectively, in that scenario, we've really not impacted anything. We've taken that one small package, but the shelves are still full with product and have been for that whole 2-month period. And I don't want you to think it's a small issue and not really broad. It's very broad. If you think of most stores that sell some type of tobacco product, they're selling this stuff. They're selling it, they believe, legally, because a lot of it is derived from hemp and then synthesized into being a stronger level of THC, but they think they're doing it legally. In some instances they know they're not. We have, in the last year and a half, taken a tremendous program of education, since we've been somewhat handcuffed in our enforcement ability, to let everyone know it's not legal. Normally, you're allowed to do it under this injunction. When the injunction's over, if it's over and they don't fall on the side of allowing it to continue, it's going to be illegal. But it's a big problem in our state. Our agents go into the stores and they see shelves full of this product. And the thing is, this is product that would require them to be licensed by the MCA. But in some instances, Maryland law says one serving size can be no more than 10 milligrams of THC. A whole package of THC can't be more than 100 milligrams. That's prescribed in law. And to sell those quantities, you have to be licensed. But some of the stuff we're seeing are labeled as 600 milligrams or 1,000 milligrams. You get the idea. Even if you had a license, you couldn't sell this for adult use. It's just widely prohibited. Other thing about these packages is many times they're highlighted with very bright colors, cartoon characters. They are using trademark type items like Oreos with a Z or Doritos to make it look like it's an otherwise trademark package. And they're clearly marketed to children. They have flavors like gelato and cotton candy, and that's who the market is children. So all of this to say, House Bill 12 will require that these intoxicating products be labeled in the same manner that the legitimate THC products in Maryland are. There's already prescribed law about how it is labeled. There are MCA regulations that explain how this stuff has to be labeled. We think this product should be labeled as well. Violating that would make these products contraband per se and let us seize them in that moment. That's not a new concept for us. We already have that authority and power to do with tobacco and alcohol products across the state. We've had it for as long as I've been in this role, which has been over 20 years. So we've had that ability, and you all are well aware of our ability to seize these products. This would allow us to make an immediate impact on the contraband, potentially dangerous, potentially metal or pesticide or contaminant product. We don't know because it's not required to go through any testing. There is a second element to House Bill 12 that Tom's going to go into more detail. I don't want to downplay that. It's an important function and issue as well. And I would just say early on, trying to do our homework, we met with representatives from convenience stores and service stations because they sell a lot of this stuff. We laid out why the bill is important and what it does, and they came back to us after presenting it to their organizations and said, no pushback at all. So it doesn't infringe on the injunction. We've got them not objecting to us, which is great. I'm asking you to help us be really impactful and effective in our enforcement and protection of Maryland citizens and ask for a favorable report of House Bill 12. And I appreciate that.
Chair Wilson, Vice Chair Crosby, members of the committee. My name is Thomas Akris. I am the Director of the Legal Legislative Division for the ATCC. And on behalf of the ATCC, I'm requesting a favorable report on House Bill 12. Specifically, I'm going to talk to you today about the Delta 8 and Delta 10 provisions that we're requesting in this bill. Back when the ATC was created in 2019, the ATCC's Field Enforcement Division, which is our sworn law enforcement division, has specific enumerated powers. It can address issues in regards, back then, it could address issues in regards to tobacco, alcohol, manufacturing, export, distribution, et cetera, et cetera. In 2023, with the passage of the Cannabis Reform Act, some cannabis-related enforcement powers were provided to the ATCC. I say that because in current law, everything that the ATCC can do, save for emergency circumstances, is prescribed in, I think it's 1-313 of the Alcoholic Beverages article, Alcoholic Beverages and Cannabis article. What this bill would do is it would add an enumerated power to the ATCC's current powers, which would allow it to issue a citation for a violation of the criminal law article. The ATCC can't necessarily go outside of its article to start enforcing provisions of the criminal law article. So what this will allow us to do is just do a citation to a retailer who sells these products to underage individuals. And this is very important because of what we're doing right now. Currently, we have a MOU with the Baltimore City Sheriff's Department in which we're going out right now piloting a program to conduct these underage purchases at a lot of the tobacco stores that Executive Director Kelly mentioned in his testimony. And so what we want to do is, in doing this, we don't want to go to the store, purchase a product, go wait 45 days to get it tested, come back after that test has been approved, then it potentially go to a court commissioner and fill out a statement of criminal charges, which could lead to a warrant. And in cases specifically to the Cannabis Reform Act, I don't think it wasn't the legislature's intent to make these low-level possession and or attempted sales to be incarcerable. So what this will allow us to do is expeditiously conduct these operations and issue a citation. And so I just wanted to put a little bit of meat on the bones as to why we're asking for that authority. And with that, I would request a favorable report on House Bill 12, and I'm available for any questions that you have.
Good afternoon, Mr. Chair and members of the Economic Matters Committee. I'm Morgan Smith, Senior Policy Analyst with the Maryland Cannabis Administration. First, I'd like to thank our colleagues at ATCC for both bringing this piece of legislation forward, as well as their partnership in the enforcement of the cannabis industry. The MCA supports HB 12 and believes it's an important bill that will help ensure consumer clarity and enforcement efforts. As Tom and Jeff mentioned, this bill references consumer protection items that the General Assembly has already put into statute, including child protective labeling, other label requirements, and tamper-resistant packaging, among others. These are items that we do not currently allow in the licensed market, and putting this bill forward will make sure that those same tools can be utilized in the unlicensed market. With that said, we urge your support on this important bill, and we're happy to take any questions.
No questions, including favorables. Favorables, we have Rusty Warren, Warren Carr, and Matthew Lovett.
I'm unfavorable.
Yes, sir.
Okay. And the other person? Brad?
Good afternoon, committee members. My name is Matthew Lovett. I live in Randallstown. My vote is unfavorable for this bill. I'm a part of the Maryland Cannabis Equity Collective. We're a collective of hemp industry business owners as well as state-regulated business owners. The bill, the packaging piece, the selling to minors piece, I totally agree with you all on that part. And specific on page 4, line 3, it states that the serving size should be 0.5 milligrams and 2.5 milligrams in the entire package. The concern is that anyone who is a medical patient or is able to get these products 2.5 milligrams or 0.5 milligrams, it's basically if you need 10 milligrams, you have to eat 20 gummies in order to get the relief you need. The trickle-down effect comes in with the stores that are carrying these products. A lot of them bootstrapped. A lot of them weren't able to afford to get into the state licensed legal market. This will hinder their businesses greatly, as well as the consumers who aren't able to afford dispensary prices. Mind you, love the dispensary. I'm a medical patient myself. And also for the accessibility of the dispensaries, that hinders them with that part as well. Lastly, those same consumers, they will go to what I call the neighbors. Sometimes it's called the illicit or underground market, but in Maryland, we're able to grow at home. And there are folks that are growing their own medicine, and they are making their own butters and chocolates and everything off of YouTube. And once that comes into play, then the state loses money off of the stores getting the taxes, and that's not a win for anyone. So I would want you all to really consider that milligram amount, because there are people who have all kind of ailments, and they need a higher dosage of THC to be able to get the relief that they need. Thank you very much.
Good afternoon, Chair Wilson, Vice Chair, and members of the committee. For the record, my name is Rusty Carr. I'm a resident of Mount Airy in District 4. I'm here opposing HB 12. It's not in this bill, but there's a tax hike for cannabis in the budget. And they're asking to raise it from 9% to 15%. When you work the math and you look at that request, they're also asking to change the split from 50% to the general fund to 60% back to the cannabis. And the other change they're making on that is they're taking that extra 10% and giving it to the administrative costs of running the program, which includes enforcement. So it looks to me like they're asking for 10 million more when you work all the numbers through for more enforcement of the cannabis laws. It's been 1.5 years now since we legalized cannabis. It's been the Wild West, and I've documented this in my written testimony of what's allowed. The tobacco stores and the sales to minors are just a small, tiny fraction of what's going on that's illegal sales. The world hasn't come to an end. There's no great need for this enforcement to happen. When the restraining order gets resolved, We still haven't resolved the lawsuit underneath. We don't know if this license caps are going to work. We do know that we haven't stopped D8 sales. It's been a year and a half. We could have easily stopped those D8 sales if we licensed. We could have easily raised much more money from the cannabis industry if we had legalized differently, instead of giving the industry $300 million in increased profits. I urge you to vote no. The world's not coming to an end. Vote unfavorable on this bill, please. Thank you.
Gentlemen, I have a few questions. We would all agree that safety should be paramount when it comes to our cannabis use, right?
That's correct.
And I believe that was part of the issue, was making sure that that anything that's deemed unsafe or untested can be taken off the shelves so people don't get sick. Because I'm the one who penciled and drafted this entire piece of legislation. And the main reason was obviously to keep it, try to kill the illicit market. But I wanted people to have access to safe cannabis. And that's what this bill is attempting to do, is make sure that if there's something deemed unsafe or untested, that is not on the shelves, because our constituents shouldn't be the test subjects, because people choose to skirt the law. And when you talk about the number of licenses and how, we could have licensed a lot more people, California right now has 10,300 licenses that are sitting open. They have 8,000 licenses that are in use, because that's what California did. Anybody who wanted a license could get one, and they're valueless. And because of that, the illicit market is booming. And while there is no perfect bill or no silver bullet, I think my question is, if we're trying to make things safe, why is this bill, why giving them more enforcement, why is that a bad thing? And also, the tax that you were talking about, sir, just as an aside, that's not something we support. That's a goal that the governor has. That's not the goal of this body, because it was to keep it affordable, to let you know that. So this bill has nothing to do with those taxes. This bill, whether those taxes are passed or not, if this bill passes, they will be using current resources to do the enforcement. But please answer my question about the safety.
Yes, I'm all for safe cannabis. Totally agree with you 100% on that, without a shadow of a doubt. Even the laboratories that are used, they have a 48-hour turnaround. I could provide those for you. They're widely used by dispensaries across the country, in New Jersey, that test the products. The concern is that when you say 2.5 milligrams for a package, you're pushing out the consumer, the patient, the person that needs it, the person that relies on this.
So that's already law. That's not new to this bill. It's already law. That's what was our intent in the original bill. So that's, again, I want to make sure we understand what you're opposing, because what you brought up is already current law. I wrote that.
Right.
So it's not in this bill.
It's, on page 4, line 3, it says 0.5.
But that's not new language. That's the current code.
Okay. So
we make exceptions for people with medical marijuana cards.
Okay.
That's go ahead, sir.
Sorry, but for the person who doesn't have a card, who can't make it to the dispensary, goes to these trusted shops that are accessible to them, those products that are higher in milligrams, the store owners wouldn't be able to sell those products, correct? So that's where my concern is for the person who needs it, and they won't be able to access it anymore.
All right. I just want to make sure I understood that was current law. Obviously, we made as many arrangements as we could with all the current cannabis licensees to make sure there's lines that they don't have to stand in. They can make we actually have drive-through dispensaries if you have that card. We have done everything in our power to make it easier for these individuals who need those higher amounts to get them. But what you're arguing is current law, sir. Yes, sir. Go ahead.
My observation is that we've tried to stop D8 and D10 sales. We could have stopped them when we legalized. We tried to do that. And we haven't been able to do that. But the hemp industry was begging this legislature to regulate the industry and allow them to get their products tested and sold legally under license. We decided not to do that. But the downside is we've had a year and a half of D8 and D10 sales that have continued on. We haven't been able to stop that. We could have stopped that if we just licensed them and said, hey, we'll let you have these licenses.
And so literally what you're saying is make everybody else go through the hoops applying so we can limit, because remember, the more licenses, the less value. The less value, the less likely this market is to be sustainable. So your theory is let everybody who wants to have one and just let the market take care of it, because that's what California did. They failed.
You're asking me to buy that capped licenses is better for the market.
I'm saying giving license out in amounts to keep them create value versus what California did has failed.
When you create value in those licenses, that value comes from the consumers. They pay higher prices.
It also comes from the demand. And at some point, the demand is overshadowed by the number of licenses. And I keep saying California for a reason, because that's what you're asking for. We've seen that done, and it failed miserably.
I'm not asking for specific licenses. I'm asking you to license the hemp shops that we're selling
all
for.
The hemp shops.
And they don't have to have the same license that existing dispensaries have. You have the ability to say, we will create restrictions on these folks.
And I guess, and I don't want to run this into the ground, but the reason that many of us here were offended by that is because when we were told about legalizing hemp is because we really wanted to make paper, shoes, the lining. It was never about any intoxicants. Nobody here voted for hemp to be an intoxicant. We were sold a bill of goods, and yes, we fell for that. So we're trying to still clean that up, because that should have never been. That was not the intent of this body. So when they come up and now say, look, we've been doing something illegal for years, legalize it, why would I reward that? Why would I even think to step in, reward something when they knew what they were doing, they knew what they told us, and they knew what they did? And now they want to come and say, you know what, we've been doing wrong for all these years, reward us for it. That's a bridge too far, sir.
I hear you. My question is, if it's too far, the cost then is that we have continued sales for the last 18 months.
Because of the lawsuit that we will resolve.
You will resolve it.
I'm waiting for the courts. That's what we have to wait for.
Yeah.
And if I'm wrong, then we'll find an alternative, but it won't be rewarding bad people that operate in bad faith. That's the last thing I'd like to do, because it sends a message, do whatever you want to do. Eventually, we'll take care of you. If that's the case, I have many clients that I used to represent. Heck, we got to give them a license too, because they're actually selling real weed. They weren't lying to anybody. They weren't saying this was for, socks or something, but that's fine. I don't want to jump into it. I think we did the safety part. Steve.
Yeah, it's kind of just a question about THC. Can I?
On the hemp-derived side. On the hemp-derived side, THCA, which is popular, hemp flower, it does provide the psychoactive euphoric feeling.
Can I do that with cannabis?
Yes.
Yeah. Okay.
Yes.
All right. That's what I want.
But the part that
go ahead.
Sorry, that I wanted to go back to was that.
Oh, okay.
Belabor the point. If you answer this question, that's fine. We don't have to keep belaboring the point. Thank you. I don't want to, like I said, no, unless you have another question.
No, that was my question.
Because we do have other bills, so we're fine. We can always talk offline. If there's no question posed, we'll move on. Thank you guys again for coming.
Thank you.
I believe that concludes the unfavorables. Moving on to the next bill. House Bill 132. Ms. Johnson, if you have a panel, please bring them up.
Good afternoon, Mr. Chair, Mr. Vice Chair, and members of the committee. My name is Allison Butler, and I'm the Division Chief of Policy Implementation at the Maryland Cannabis Administration. I'm here today in support of House Bill 132, MCA's on-site consumption departmental. MCA is proposing a smoke-free framework that we think is a really exciting opportunity for social equity applicants. MCA is authorized to issue on-site consumption lounges in the second round, and so we want to make sure that those who are applying for those licenses have a viable model to work from. Our proposed framework clarifies how those businesses will function in the market and also strengthens health and safety protections, like making sure that those businesses are subject to Maryland's laboratory testing protocols. House Bill 132 also creates a pathway for event registration. We understand that there's a lot of interest in cannabis events around the state and want to make sure that there are guardrails in place and also to advance market growth by encouraging cannabis beverages. Our bill proposes 3 tiers of cannabis events. The first is a cannabis-friendly event that doesn't involve any sales, an event where the event holder can dispense cannabis beverages that they've acquired from another licensee, and an event where a licensee who has a vendor permit can dispense edible cannabis products to event attendees. Our framework is a starting point, and we welcome any input and suggestions from this committee for how to make it more, to improve health and safety measures for Marylanders. And last but not least, Audrey Johnson, the Executive Director of the Office of Social Equity, is here to talk about the social equity components of our bill. Thank you.
Thank you. Good afternoon, Chair Wilson, Vice Chair Crosby, and the members of the Economic Matters Committee. Thank you for the opportunity to testify today. I am Audrey Johnson, Executive Director of the Office of Social Equity. I have submitted written testimony, which I'm sure you all have reviewed, but I will take a moment to highlight some key points orally on HB House Bill 132. It's an important step to ensuring that Maryland's cannabis industry remains equitable, well-regulated, and accessible to those who have historically been left out of the market. Key highlights are expanding economic opportunity for social equity licensees. This bill prioritizes social equity applicants, giving them the first opportunity to establish on-site consumption businesses and host cannabis events. By doing so, it helps level the playing field and ensures that those most impacted by past cannabis policies have a real chance to succeed in the industry. It also creates a clear regulatory pathway for legacy event planners to transition into the licensed market. Public health and consumer safety. This bill takes a thoughtful approach by restricting on-site consumption to edible cannabis products, addressing concerns about secondhand smoke. That said, we acknowledge that the smoking remains the most common method of consumption, and we look forward to working on policies that provide safe and legal spaces for all cannabis consumers. The bill also ensures that the consumers receive proper education about cannabis consumption, reinforcing responsible use. Thirdly, local control and community input. The legislation respects local jurisdictions by allowing them to opt in, set zoning requirements, and regulate hours of operation for on-site consumption businesses. This balance is critical to fostering public trust while expanding economic opportunities. And then last, positioning Maryland as a national leader. 12 other states have implemented on-site consumption models, but Maryland has the chance to lead with an approach that is both equitable and business-friendly. By refining these provisions and ensuring accessibility for small businesses, we can develop a strong, inclusive model. This bill is a necessary step in strengthening Maryland's cannabis industry, promoting responsible consumption, and advancing economic equity. I urge the committee to support this bill and continue working with us to refine Maryland's approach to on-site consumption. Thank you.
I believe we do have one online favorable. Ms. Butler does have you signed up favorable with amendments. Were you favorable on the bill?
Favorable with amendments, yes. And I can explain that.
Oh, okay. All right. Let's get to the last favorable here. Paulette Smith.
Greetings, Chairperson, Vice President, Vice Chairperson, and esteemed members of the committee. My name is Dr. Paulette Simone Smith. I am a licensed clinical social worker, a cannabis science educator, and a business owner committed to social equity in the cannabis industry. I strongly support this House Bill 132 legislation because it prioritizes equity, public safety, and economic growth. Limiting on-site consumption licenses to social equity applicants is a step toward addressing past injustices from cannabis prohibition by providing those historically excluded from the industry with a legal avenue for participation. Now, this bill ensures that social equity applicants like myself who have faced barriers due to prior related enforcement or financial business underpinnings have first opportunity to establish viable businesses in this legal regulated market. As a social equity applicant not selected in that first round, I understand firsthand how critical it is to have a fair opportunity to participate in this emerging industry. On-site consumption spaces also provide safer, regulated environments where consumers can receive education on responsible use rather than turning to unregulated alternatives. Allowing repackaging and processing in these establishments supports quality control and dosing accuracy. Additionally, cannabis events create economic opportunities for small businesses like myself and educate consumers in a legal structured space. Granting jurisdictions authority to regulate hours and event parameters also ensures community safety. This bill is a necessary step toward justice and inclusion in cannabis policy, and I urge you and your support, and thank you for your time.
Thank you, Chris.
Thank you, Mr. Chair. So I just want to touch on one brief part of your testimony. At the very beginning, you were talking about non-combustibles or so non-smoking. Could you just, I may have an additional question. Could you just repeat your testimony on that front and why this is important as you're delivering this bill?
So our model is a smoke-free model. That's how we've contemplated it, and so it doesn't allow indoor or outdoor smoking as we've written it, and that's for a few reasons. I think the first is that we're hoping that this can push the market to diversify and create some new edible cannabis products, such as the cannabis beverages that we have sort of created a pathway for in this bill that are a lower dosage cannabis product. And then also we have concerns about really the viability of a smoking consumption lounge because these businesses will be in business districts in areas with neighbors that may not want the cannabis smoke and odor as their next door neighbor. And then and because there's so much local control that we have written into this bill, which we think is a great part of it, we would not want businesses to not be able to locate in various counties or municipalities because they don't want to deal with the outdoor smoke.
Okay, so this is an essential part of the bill because for you to get this on-site consumption, you've concluded that you can't do that if you're going to allow smoking. It has to happen through other forms of consumption. Is that
That's right.
Yeah, okay. Thank
you. Seeing no further. Pippi.
So I'm looking at these like community events or Burning Man events, whatever you want to call them. I mean, 12 hours a day, 4 days. There seemed to be very little restrictions on any of that. And then there was some testimony from someone, and this is new, right? This wasn't in the original legislation.
Correct.
So this is a brand new thing. The biggest concern they have is, I guess, the delayed impact of eating gummies. You know, you eat a bunch, they don't kick in for 30 minutes or something like that. So, I mean, could you address some of that? I mean, is there a huge demand to have some outdoor festival where people are running around eating gummies and then getting in their vehicles and driving away, or?
I think there is interest. We've heard from folks in the industry and community groups that there is a lot of interest in having cannabis-friendly events. We have thought a lot about the public safety issues and how to mitigate the concerns and the concerns around impaired driving, the delayed onset, and in the bill has a number of different provisions that address those concerns. It doesn't allow events or the on-site consumption establishment to provide cannabis products to people who are already intoxicated. It limits cannabis products to only single-serving products. And then we've explored other jurisdictions, other states that have done cannabis events and on-site consumption lounges, and they provide some creative ways to mitigate those concerns, like requiring low potency options, requiring businesses to have partnerships with rideshare programs to offer discounted rides, and generally requiring event holders or on-site consumption lounges to have plans in place that the commission or the agency would approve to reduce those risks. And generally, we would welcome input from this committee and from our agency partners for how to further strengthen those protections in the bill.
So 4 days, 12 hours a day, could I have that like next to a school?
So one of the great things I think about this bill is that it embeds a lot of local control. So
Because usually when we do a lot of, cannabis-related bills, sometimes we take away the local control,
not in this one.
not in this one, okay.
So for on-site consumption and for events, it's really up to the local jurisdiction, the county or the municipality, to decide when those events can take place, whether they happen at all. And there's additional zoning standards that local governments could put in place for these businesses and the events.
And can you explain the social equity piece? Like who does that apply to?
Sure, and Audrey can jump in certainly. So the on-site consumption establishments are only available to social equity applicants, and the vendor permits, which is one component of the event registration, vendor permits are only available to social equity licensees.
Okay, so, and like who fits in that category? What's a social equity individual?
So a social equity applicant, actually, Audrey, do you know?
It's individuals who have licensees. We went through a lottery. This was a very race-neutral way of putting it out, where you had to have lived in an area disproportionately impacted by the war on drugs. You could have gone to school in an area for at least 5 years in a zip code that was basically disproportionately impacted by the war on drugs. It was a very race-neutral way, written after the Harvard decision. We passed this 2 years ago. So that's when they talk about social equity. Beyond what you may formulate, it really is very race neutral. It allows anybody, if you've just lived in an area that was, disproportionately impacted by the war on drugs, and that's just not over policing, that's also just drug sales, things of that nature in your community, then they were the ones who were allowed to apply. And they did through by a lottery. And then after the lottery, they were just pretty much numbers picked out of a hat.
Okay, thank you.
I did want to ask because I will say honestly, just for people listening, I do believe that this is premature. I think we've discussed this. I understand this is a point in time to get there, but for some of the issues we've had as far as we're still getting this off the ground, and I just want people, especially on my committee, to understand that I believe that while we put these plans in place in the administration, Office of Social Equity has done their job by bringing forth the bill. By no means do I feel like we're being forced to do anything, because I know that we have a lot of other things to resolve as far as the safety, who's going to inspect these facilities, are there out-of-state people coming, there are a bunch of things I know that people are concerned with, and we're still having a hard time getting our social equity licenses placed, so I'm sure we would have a devil of the time getting on-site consumption placed. So before we jump too far, I believe that we're just laying this out as a general framework, i.e. a conversation for a later time.
Briefly, do we have a test yet that can determine whether you're high on cannabis that law enforcement uses?
So my understanding is that you can test to see if someone has cannabis in their system, but and you can look at a person and assess if they show signs of intoxication. But I think the limitation of those tests is whether you are currently high. And I'll note that this is...
So it's not like we don't have a breathalyzer for a police officer to use?
That is my understanding.
One of my biggest concerns with something like this is that we don't even know we can't even charge you if we think you're high. We can't do that yet. And we're taking this product and we're making it a bigger exposure to people with no real guidelines on it, no guardrails to prevent somebody from sitting and eating 2 pounds of gummies and coming out of there sky high and driving. That would be my concern with the bill. I don't think we're doing the proper thing for health, if you get my drift. Wouldn't you agree?
I understand, and I think, and again, that is something that we have talked about a lot, and I think that there are ways that we can put in more limitations around limitations that would prevent someone from having too many gummies or
you understand there are ways to do a lot of things, but we're putting something out there saying, okay, come one, come all. We're going to have a little event today. Everybody's going to eat a lot of gummies and do all this stuff, and then we're going to send you on your way. It's great to do that. It's noble, but we don't have a way to sit back and protect the people that this could affect.
I understand.
But
yeah,
thank you. I appreciate your comments. Thank you.
Thank you, Mr. Chair. I appreciate the conversation. I looked through the testimony, and maybe there's other people that are going to testify, but I didn't see anything from law enforcement, and I'm wondering if there's been any weigh-in or any testimony provided by, you talk about local control, local law enforcement. I would be very curious, and I would like to really find out from our Sheriff's Department and our law enforcement, because for a lot of the reasons that my colleagues have brought up, that's a major concern.
Mm-hmm.
And so, and like we've said, there's local control and then there's not so local control. So those are my 2 concerns with this legislation. So and I appreciate the chairman's comments. So thank you. Not a question, but.
Thank you, Mr. Chair, and thank you for bringing this bill forward. I also have a quick question. I know for the consumption piece, I appreciate the work to make sure that it's not smoke and that it's consumption orally. But just want to better understand: is it only consumption of like prepackaged materials, or could you do I know that it's popular in other states that you have you can go to events where they cook with cannabis oils. So is that allowed? Or is this just prepackaged stuff? How does that work?
So the way this model would work is that an on-site consumption lounge would be able to acquire finished cannabis products that have been packaged and tested, and they could repackage them, so put them into single serving form, like a single brownie or something. Or they can acquire cannabis from another licensee and infuse it into their own products. Also like a beverage or a brownie or a butter. But if they do that, they would have to comply with our testing protocol. So they would have to take a sample of their batch and send it to an independent testing lab so that they can test it for potency and accuracy of labeling and purity and stuff like that.
Okay, so it couldn't really be any cooking on site of
Well, they could cook on site, but it wouldn't be you're imagining prepping right in front, in real time and dispensing it without getting it tested first.
Okay, great, thank you.
Mm-hmm.
And obviously, that's another issue because these things take about, 2 weeks to get tested? So you have to make your butter, mail your butter, wait for the results to come back, and hope that people stick with that and are very honest when they come to these events, and they only use the butter that they've tested, not all the other tons of butter that they made afterwards. So again, these are issues that we know hills we have to climb before this can come to fruition. I believe that that's all the questions for the favorable with amendments. I do believe we're now on to the other favorable with amendments. Ashley Bagwell, Joe Breesy, and the other 2 are virtual. Huh? Weed butter?
Thank you, Mr. Chairman, members of the committee. What's his name? Here on behalf of the Maryland Wholesale Cannabis Trade Association. I'll be very brief. Mr. Chairman, our main concern is that the bill would award 15 new processor licenses before any of the processing licenses have gotten up and running, and it shouldn't be a backdoor way to get a processor license. So there are other issues that we could address, but that is our major concern.
Good afternoon, Mr. Chairman, members of the committee. Ashley Bagwell on behalf of the Maryland Dispensary Association in support of House Bill 132 with amendments. I'll focus my brief comments on the event license part of the bill. As you heard previously, this bill envisions two scenarios. One where a venue or a group can get an event license and then have vendors, which would be licensees, come in and set up what I would liken to be a pop-up shop and sell products to consumers. The other scenario is where you have a venue get a license and they sell products through their staff. We are supportive of the former and opposed to the latter. We feel that dispensary and dispensary agents spend each and every day around cannabis and cannabis products. They understand the products, they can answer questions, they can speak to potency, they are trained to recognize impairment and intoxication, and so we feel that dispensaries should be the people at event locations that are responsible for that retail function. And so that's one of our amendments, Mr. Chairman. We've submitted some other comments. I'm happy to answer any questions.
Ashley, you're the Maryland Dispensary Association?
Yes.
Okay, so on page 2 of your testimony, you get to the question I was asking the prior panel on, which is related to the combustible products.
Right.
I'm only going to ask this because in the testimony you said many people, especially renters, are not allowed to smoke or vape in their place of residence. What do you mean by they're not allowed?
So I'm glad you asked that question. I went back and forth as to whether or not I was going to raise that in my testimony. As we testified in 2022, we strongly believe that there is an equity argument with regard to on-site consumption lounges. There are people who, and in the previous panel, you did hear that the majority of products sold at dispensaries are combustible products. And as I included, as you just said, and I included in my testimony, there are people who may rent an apartment or a house where they're not allowed to smoke in their homes. And so on-site consumption lounges provide people who can't do that a safe place to smoke.
But when you say allowed, are you saying that the landlord doesn't allow it?
Yes.
Or, okay, so there's no Maryland law that
That's correct. Yes.
Because they're doing it anyhow. And I think what you're saying in the bill, they're going to find new ways to consume cannabis. And one of those ways is not going to be smoking. Because I got to tell you, it's a pervasive problem. It came up yesterday in the premium cigar bill. And I asked the question in the prior panel. And if there's a Clean Air Act, and I believe that there is, and we are regulating secondhand cigarette smoke, I can tell you we're not regulating secondhand marijuana smoke. And, I'm going to oppose the bill, and it doesn't sound like the bill is going to move, but at some point, when you start having bills that talk about and address alternate forms of consuming cannabis that don't include smoking weed, right? I mean, that's a direction. I don't know if it's the right direction, but I can tell you that for many people that don't smoke cannabis, that have to live around and walk the streets and smell it, it's a problem.
I understand your concerns. When the legislation that passed in 2022 with regard to on-site consumption lounges did allow for outdoor smoking. Yeah. And so our preference was for that piece in particular. Thank you.
No further questions for this panel?
Thank you, Mr. Chairman.
Thank you.
Go ahead, ma'am.
Good afternoon, everyone, and thank you for the chance to weigh in on HB 132. My name is Queen Adesui, and I'm a drug policy reform advocate and a partner at Reframe Health and Justice. As drafted, this bill is a step forward in the right direction. However, I'm here to offer a recommendation that would significantly improve the bill's impact across harm reduction and consumer safety. My recommendation is to expand on-site cannabis sales and consumption to include inhalable cannabis products at qualifying outdoor events and venues. This bill currently excludes cannabis flower and vapes, products that account for 88% of Maryland's cannabis sales. Flower alone represents 60% of the market, with many medical cannabis patients relying on it for conditions such as PTSD, chronic pain, and epilepsy. There's a harm reduction and consumer safety gap left by carving out legal access to regulated, tested options for the most preferred modes of consumption by Maryland cannabis consumers. It is important to note that my recommendation here is focused on outdoor events and venues, specifically because outdoor events do not require the same intensive infrastructure requirements necessary as indoor spaces to reduce harms associated with smoking. Without meaningfully including inhalable cannabis products, we leave the door open to unregulated sales of untested products, which undercuts the public health benefits and safety benefits of comprehensively regulating cannabis access entirely. Conversely, more comprehensively regulated cannabis products, including flower and vapes, at qualifying outdoor events and venues, allows for age-gated restrictions, limitations on product potencies, limits on the number of products purchased by consumers, limitations on where sales can occur, where consumption can happen, et cetera, et cetera. These are regulatory policies that do not exist in the unregulated market, but can be utilized to facilitate safe use amongst adults and ensure safety precautions are in place, including consumer safety and education on responsible use for those who do partake in cannabis. I co-developed a proposal for an outdoor live events cannabis retail sales program with my colleague here, Caroline, that includes 3 different harm reduction focused sales models that ensure sales and consumption are controlled in a way that prioritizes the health and experience of all guests, cannabis consuming or not. I emailed each of you information about this ahead of this meeting. Excited to answer any questions that come up. Thank you so much for the time.
Thank you, ma'am. Seeing no questions, we now move to the unfavorables. Mr. Warren Carr, Shanetha Lewis, and Tyshawn Ellis.
Good afternoon. I want to say thank you to the committee chair, Wilson, and vice chair, as well as members of the Economics Matters Committee. My name is Shanetha Lewis. I am the executive director of Veterans Initiative 22. We are a nonprofit organization whose mission is veteran suicide prevention through affordable and safe access to medical cannabis. We are here today to regrettably say we are unfavorable for this bill. I just want to express that our line between unfavorable and favorable with amendments was razor thin. So we want to begin by expressing our unwavering support for the establishment of on-site consumption lounges and cannabis events. I recognize and respect that this bill represents a vital step towards creating structured opportunities for safe and legal cannabis use within the community, fostering equitable participation in the cannabis industry while prioritizing public health and safety. However, based on the current parameters that in this bill, we do not believe that it will leave consumers nor those who wish to own a consumption lounge with a viable business structure. The regulatory framework does not create an economically viable nor sustainable business structure, and it also ignores the various medical needs of cannabis patients here in Maryland. The section of the bill that we primarily choose to oppose is that it grants political subdivisions the authority to unnecessarily limit consumer choice by prohibiting or restricting the vaping or smoking of cannabis in on-site consumption establishments. By allowing local governments or the smoke-free model to be sustained, this excludes and undermines the purpose of providing a safe and legal space for consumption, potentially driving consumers to more unregulated areas. It disregards the needs of individuals who prefer or require inhalation methods for faster onset and more precise dosing. I think one misnomer here is that edibles and smoking give you the same effect, and they do not. It is not the same effect. Edibles last much longer, and that also there's a misnomer that you can dose more precisely. That's incorrect as well. I support the bill's emphasis on ensuring social equity by limiting applications for consumption lounge licenses to social equity applicants, as well as its safeguards to prohibit intoxicated patrons and underage access. but cannabis is medicine. It needs to be treated as such. And for those reasons, we urge an unfavorable, regrettably, for this bill.
Ma'am, on the consumption, the individuals who need the medicine, they can still take that at home though, right?
So for some members, like veterans, if they live in government housing, they cannot consume at home if they choose an inhalation method. Can't consume in their car, can't consume in a park. So where are they going to consume if we go with a smoke-free model? As smoking is the #1 choice for both patients as well as adult use consumers.
And I understand that. I just say we also have the Clean Indoor Air Act.
Absolutely.
And that's where we are running, I don't know if we're running afoul of that. There's really no way around that. Obviously, like I said, and honestly, nothing we do here is going to cover everybody when it comes to that. So I just want to make sure people can still, I guess your thing is they live in housing?
Well, for those who may live in housing or who rent and are unable, but for the veterans, what we're hearing, what I'm hearing is I live in government housing or I have a stipend and I cannot consume in my chosen method or the method that works the best for my disease.
For people that are no longer in the military?
Yes. For, if there's veteran homelessness, like Platoon 22, they couldn't consume in those houses, in that temporary housing. That is a wonderful program that they offer, but it leaves out veterans who are medical cannabis patients. They have nowhere to consume.
Yeah, and I guess the problem is we're never going to capture everybody. We're never going to capture everybody in a bill, because you've heard, and one of the main complaints most of us hear here is, while you're not supposed to smoke in public, boy, you smell it everywhere. And a lot of people don't enjoy that. And it really is, the needs of a few versus the needs of the many. A lot of people don't want to be around that. I don't. I'm not like, some other, delegates from Baltimore City. I don't really get into it like that, but. No, but I think that, it's for some folks. So I just want you to know that we're very mindful of both sides in trying to deal with this. And like I said, although this is not ready for prime time, having the Clean Indoor Air Act makes it very challenging for us.
It does. I did maybe have a question. I wasn't sure, and I've looked this up, how that cigar lounges are able to.
The reason again, we had a hearing yesterday, and I don't want to go, I'm sorry guys, but basically those that got in were able to, they invested money and were licensed prior to anybody bringing this to that attention, so that the counties licensed them, and they've invested money, hundreds of thousands of dollars into that. So that's why they still exist. We're not opening up, and I don't believe we're going to have the ear to open up any new ones for just that reason, because we're not going to start, you can't set that precedence. So, but thank you, ma'am. Go ahead, sir.
Thank you, Chair Wilson, members of the committee. For the record, my name is Rusty Carr. I'm a resident of Mount Airy in District 4. I'm here in opposition of HB 132. We talked a little bit about the lasting, how long the effects last. Edibles can last 4 to 6 hours. The plan here for events is going to end up with people leaving the event high. To the other delegates, note, police do have a method to detect inebriated drivers, no matter what substance is affecting their faculties. So there's a training program for that. There's the ability for them to do that. But to Chair Wilson's comment, public safety is a concern. When I look at this plan to ask people to go to events to not inhale and to use a different method of consumption that they may or may not be familiar with, especially the ones who aren't familiar with, there's going to be trouble. Dosing is a lot harder for edibles. There's nothing in this regulation that prevents events from selling regular edibles, which have a longer period of onset, which are more likely to cause problems. There's tons of problems like that that are in this bill. They need some more thinking about that. We need lounges. We need events. Is there a friendly unfavorable? I'm unfavorable, but we need these things. We need them to be done right. We need them to be thought through and understand how cannabis works before you make these regulations. This bill does not do that. It needs more work. I urge you to vote unfavorable. Thank you very much.
And sir, I'll say that throughout your testimony today, we kind of know where you're coming from. So you sent a good signal. We get you. Chris?
All the time here in Annapolis. To the lady to the left there, I just want to, on the bill, right? Again, I'm not going to support the bill, but what resonates with me is the part that we're getting away from the things that, you know, the smoking. I'm just going to be honest with you, but you're defending that part of it. Like and I guess I need to better understand that, because I imagine that the industry, for it to go mainstream and to follow and be compliant with federal law, you're going to have to reconcile this smoking thing. The smell is not going to go away. The only answer to this is going to end up being whatever butter is and whatever gummies are and all those sort of things. I mean, that's sort of like, maybe it's a bill before its time, but if there's one part of this bill that, as a Republican, I can resonate with, is it's going to address at least one of my many concerns with the industry.
You know, I can completely understand that.
Which has to help your advocacy, I would think.
The smell of cannabis can be pungent, and there are some that don't like it. There are others that do, like myself. However, as I stated again, whenever when you're smoking cannabis, it's a faster onset. It doesn't have to be metabolized, and it's actually not as strong as an effect that you get through eating an edible. You could also choose vaporization. You can choose that method as inhalation, and that does not have such a pungent smell. It doesn't have the smoke. It's combustible, but it's a different type of, as we know, smoking cigarettes and vaping, that the cloud disperses quicker because it's a water vapor. So there are ways that we can still provide inhalation without providing smoking. And then, you know, to my point earlier, that although, you know, again, we have these cigar lounges and we're offering this reprieve, but we're not thinking about cannabis patients who use smoking. I'm not talking about parties or events or chilling. I'm talking about cannabis patients, who are my number one priority, who choose this method of consumption because it works best for their disease symptomology.
That's fine. Perfect. Thank you.
Seeing no further questions, I do believe we do have a favorable with amendments that we missed. Ms. Caroline Phillips.
Thank you. Good afternoon, Chairman Wilson and members of the Maryland House Economic Matters Committee. My name is Caroline Phillips, and I'm the founder and executive producer of the National Cannabis Festival. NCF is the nation's largest annual ticketed cannabis event, attracting 35,000 guests annually, with more than 1/3 of our guests calling Maryland home. I want to express excitement about HB 132 and the effort to regulate on-site cannabis consumption at certain venues and events. Cannabis is already present at outdoor live events, and it has been for as long as many of us can remember. Now we have the opportunity to regulate how it's being served and consumed at live events, as well as creating a program that can generate tens of millions of dollars in revenue for Maryland's social equity licensees and the state. My recommendation is to amend the bill to include inhalable cannabis, and here's why. Based on data provided by the MCA, it is undeniable that inhalable flower and vapes are the most consumed form of cannabis in Maryland, making up 88% of the market compared to just 12% for drinks and edibles. That's $510 million in flower and vape products in the final 6 months of 2024, compared to just $70 million in edible products. Including inhalable cannabis products does not mean we are creating a free-for-all for smoking in public. It allows us to select and scale how cannabis is present at events, to create a healthier environment for all guests by ensuring that if inhalable products are allowed, they are controlled and put in a place where they do not bother all guests. We can also reduce the presence of unregulated and untested products on site when we regulate all cannabis products. If we leave cannabis flower and inhalable products off the table, the industry and the market stand to lose those same tens of millions of dollars, and the unlicensed entities will fill that void. They will still be at the live events. We cannot turn a blind eye to the cannabis consumer trends in the state by omitting the most popular form of this plant for patients and adults 21 plus. I believe that we can take a broader look at this issue and develop pragmatic models that allow adults 21 plus access to safe tested products and allow folks who don't want to be around cannabis to get that space. Thank you for the opportunity to share my thoughts.
Thank you very much, ma'am. See no questions. I believe that concludes your testimony as well as this bill hearing. Thank you very much. Delegate Wu, do you have a panel, sir?
No.
I'm sorry?
No.
Come on up, Chris.
Okay, we changed. Should I go ahead? Okay. Good afternoon, Chair Wilson, Vice Chair Crosby, and Madam current Chair Panorama, and a member of the Economic Matters Committee. For the record, I'm Delegate Chao presenting HB 823, the Generative Artificial Intelligence Data Transparency Bill, and I respectfully request your favorable report. Over the past decades, generative artificial intelligence has experienced exponential growth, with its market size increased by 690%, from $5.7 billion in 2020 to $44.9 billion in 2023. Projections suggested it will surpass $207 billion by 2030. However, with its market size increased by this rapid expansion has raised significant concerns about the transparency of the data used to train these AI models. This bill addresses that concern by requiring developers of generative AI and system services to publicly disclose on their website information about the data used to train their system. Specifically, they must provide a high-level summary of the data set. It's not the data itself, it's a high-level summary of the data. Why this bill matters? AI models are often trained on data sets that may contain biases, which can lead or even perpetuate racial discrimination and other inequalities. Without transparency about the data used, it becomes really impossible to identify or address these issues. By mandating that developers publish clear documentation about the training data set, this bill ensures that bias in AI will be identified and corrected before the system are deployed to the public. A survey conducted by TELUS Digital Experience found that 86% of the respondents have integrated generative AI into their daily lives. Marylanders deserve to know whether the tools they rely on are built on accurate, reliable, and unbiased data. This bill empowers consumers and policymakers to hold developers accountable, raising the standard for the reliability and accuracy of generative AI models. Transparency fosters trust by requiring developers to disclose key details and a high-level summary about their training dataset. We can ensure that AI innovations are developed ethically and responsibly. This legislation is not intended to hinder developers, but to encourage the adoption of safe and responsible practice that benefit everyone. Other states like Utah and Colorado have already taken steps to promote AI transparency. Utah's Artificial Intelligence Policy Act requires businesses or individuals use generative AI to interact with others to disclose that they are communicating with an AI system. Similarly, Colorado's SB 24/2005 mandates that developers provide a publicly available statement summarizing the AI system they have developed or they're using, how they plan to manage potential risks associated with their algorithm. In conclusion, I urge this committee to support this bill by requiring developers to disclose critical information about the training dataset used to train their models. This legislation will help ensure that Maryland fosters a fair, accountable, and trustworthy AI technology. Thank you.
Thank you, Delegate Wu. Are there any questions? Seeing none. Okay. Thank you very much.
Thank you.
We have favorable with amendments. We have Brianna January and Evan Richards.
Good afternoon, Madam Chair, esteemed committee members. Brianna January with Chamber of Progress.
seeking a few adjustments to HB 823. Chamber of Progress is a tech industry coalition advocating for the progressive future of tech and inclusive access to that future. I'll note that our partners do include AI innovators like Amazon, Apple, and Google, but they do not have a vote or veto on our positions. We commend the good bill sponsor for seeking transparency in AI training. Transparency empowers both consumers and policymakers. At the same time, a healthy competitive marketplace is essential for promoting quality services for consumers and encouraging companies to innovate. Committee, ideally, data disclosure is akin to nutritional labels on food. Useful information to help the public make informed choices. Critically, it is not a step-by-step recipe revealing exactly how a signature dish is made. HB 823 can be a step in this direction, but some changes are required. As drafted, the bill requires disclosing the full recipe instead of just the nutritional label. For example, the bill's broad mandates requiring detailed disclosures of training data sets such as the source and characteristics of the data may lead to loss of competitive edge for developers. Revealing extensive details about training data can enable competitors to reverse engineer successful AI models, undermining innovation and competitiveness in the marketplace. And HB 823's extensive disclosure mandates may also create a deterrent effect, especially for smaller AI innovators looking to come to Maryland. As such, we request amendments to the bill to require less detailed training data be disclosed and instead require more generalized, less sensitive data. And we're happy to work with the committee and the good bill sponsor to strike that appropriate balance on the language. With that, again, we support the bill in concept, but we do feel that the reporting is a bit broad and may inhibit smaller innovators in the state. Thank you.
Thank you, Madam Chair, members of the committee. For the record, my name is Evan Richards. I'm the head of government community relations for the Maryland Bankers Association. And we're here favorable with amendments on House Bill 823. And specifically, we're looking for language that deems the obligations set forth in the bill satisfied. If a bank is subject to the jurisdiction of a state or federal banking regulator who publishes guidance or regulations that apply to the use of AI. It's no secret that the Maryland banking industry is one of the most regulated industries in the country. The information that is required to be posted on this bill is already available to bank examiners. And it's important to remember that, in order for, banks have to be in compliance, with federal and state laws and regulations, and bank examiners have the ability to take action if they do find that the generative AI, in use is, indeed discriminatory in nature. I'm more than happy to provide, additional details, but I think the committee understands the other point is that, this is already examined, and regulated by, regulators. So with that, we urge the committee to support legislation with amendments.
Thank you very much. Are there any questions for this panel? Delegate Chi.
Thank you, Madam Chair. Thank you for the testimonies. My question is for the Chamber of Progress. I've never heard of the organization. Can you explain who are your members? How's your organization funded? Because I understand it's a tech industry association, so how is that, for example, different from like a TechNEC? Who are your members?
Absolutely. Thank you for that question, Delegate. Chamber of Progress is a relatively new organization. We are a center-left tech industry association. Our members include household names like Uber, Amazon, Apple, Google, et cetera, Lyft, Airbnb. Unlike the traditional model of industry associations, however, none of our members have a vote or veto on our positions. They are completely led by staff and our center-left values around abundance and economic opportunity for all with tech innovation.
Any additional questions? Seeing none, thank you very much. Members will now move to the unfavorable. We have Grayson Wiggins with the Maryland Chamber of Commerce.
Good afternoon, Madam Chair, members of the committee. Grayson Wiggins here on behalf of the Maryland Chamber of Commerce. You have our written testimony, so I'll be brief. The primary concern that we have is the potential cost and operational burden that this level of disclosure would place on businesses. As the woman that was sitting here mentioned, I'm not sure of another state that has enacted this level of disclosure requirements. And I would just point to the fiscal note, the small business effects section, where DO-IT advises and DLS concurs that the bill could be interpreted to require substantial ongoing effort and costs for developers, many of which begin as small startup companies, and would likely require them to need permanent staff. And we're concerned that given that this is a new industry and the note about the startups, that this bill could unintentionally stifle innovation here in Maryland. And so for those reasons, we are concerned, Madam Chair. Thank you.
Thank you. Do we have any questions? Seeing none. Much appreciated, Grayson. We have virtual testimony. Margaret Durkin from TechNet.
Good afternoon, Madam Chair and members of the committee. My name is Margaret Durkin, and I'm the Mid-Atlantic Executive Director for TechNet, a technology trade association. Thank you for allowing me the opportunity to speak today on House Bill 823. TechNet and our member companies are committed to the responsible development and deployment of artificial intelligence. And many of our member companies already produce their disclosures on how their AI model works for public consumption. Targeted transparency of any bill related to this subject matter should be the goal. And we want to avoid consumer fatigue and avoid unnecessary burdens placed on businesses. The volume of training data that this bill would require to be disclosed would perhaps overwhelm consumers just because of the sheer amount of data it would provide, and again, lead to that consumer consent fatigue that we see in other aspects on the internet. And while we believe that this isn't the Speaker's intention, House Bill 823 fails to provide essential protections for intellectual property or trade secrets. Expertise and judgment is what differentiates some of our providers, and we believe that that would unintentionally harm competition because their trade secrets would be out there for the public. Prescriptive transparency requirements depart from current standards related to transparency, and a perhaps better obligation would be to provide a summary of info that would be used to develop generative AI systems, including categories. We believe that could potentially be a more workable option for our companies. And another option that we're suggesting is the requirement for businesses to retain info for reporting and auditing, as opposed to putting it on a public website, again, with the concern that that could lead to trade secrets and intellectual property being out there for the public. And final thought is that we would expressly like any bill to state that this bill does not provide for a private right of action. Thank you for the opportunity to speak today.
Thank you. Any questions for this witness? Seeing none. Thank you, Ms. Durkin. We now move to our last virtual, Megan Stokes.
Thank you for the opportunity to speak today. I am Megan Stokes. I am the State Policy Director for the Computer and Communications Industry Association. We are an international not-for-profit tech trade association whose member companies would be impacted by this proposal. This bill lacks clarity around definitions, including what constitutes as training. The legislation also departs from emerging U.S. and global transparency standards by not allowing for trade secret exemptions. CCIA does suggest permitting developers to omit disclosures that could cause a loss of trade secret status or that could harm the security or integrity of the system. At a minimum, we request that there would be a provision to permit such disclosures be made privately to the state rather than publicly. We do also join in with TechNet suggesting an explicit provision prohibiting a private right of action. Without this provision, we do feel that small businesses could be disproportionately impacted. We do appreciate the committee's consideration of these comments and stand ready to provide additional information as the Maryland General Assembly considers proposals related to technology policy. Thank you.
Thank you. Are there any questions? Seeing none, thank you very much, Ms. Stokes. That concludes the bill hearing on House Bill 823. Members, we're going to jump ahead. We have a guest legislator here with us. Since the rest of our bills are from within the committee, we're going to jump to House Bill 1020. Delegate Polakovich-Carr.
Thank you, Madam Chair. I have a few witnesses. Could they come up with me as well? That would be Marceline White, Michael Patty, and William Steinweidel.
Yes. Thank you.
All right, well, good afternoon, committee. For the record, I'm Delegate Julie Polakovich-Carr, here to present House Bill 1020. This bill would prohibit the inclusion of information about a person's medical debt on a consumer report, also known as a credit report. And I want to be clear about why this bill is before the committee. 5 weeks ago, our country had a nationwide rule to prohibit all medical debt from consumer reports. That rule was issued by the Federal Consumer Financial Protection Bureau in early January. The new presidential administration, however, has ordered the Bureau to halt implementation of the rule and is trying to dissolve the agency altogether. So without a federal regulator to protect the interests of consumers, Maryland should act. 1 in 5 Americans have some amount of medical debt, but there's a disproportionate impact on older Americans and veterans. On average, this debt is just $579. So we're not talking about big amounts of money. Yet this debt, when it appears on a credit report or background check, has a negative impact. It makes it harder for Marylanders to rent an apartment or get a mortgage, to secure a job, or to access credit to buy a car or start a business. You might be thinking, don't lenders need this information? But the short answer is no, because research shows that medical debt is a very poor predictor of whether someone can repay a loan. For that reason, VantageScore and some other companies no longer use medical debt in the calculation of credit scores. Additionally, the 3 largest credit reporting bureaus have voluntarily removed about half of medical debts from their credit reports. Importantly, because these were voluntary changes made by companies, they can be undone at any time. And that's why the federal government acted to ensure that no medical debt would be included in consumer reports. Already 10 other states have enacted laws like this one, including our neighbors in Virginia. And I'm sure you're going to hear today from the industry that this bill is preempted under federal law, but I would point committee members to the advice letter that I uploaded with my testimony from the Office of the Attorney General, and that they advise that federal law does not preempt state action on this front. And I would also point the committee to the interpretive rule issued by the Consumer Financial Protection Bureau in 2022 that made clear that states are free to act to prohibit medical debt from consumer reports. Notably, the General Assembly has already taken this advice and acted in similar ways. Thanks to the work of this committee, this last year we prohibited certain kinds of criminal records or proceedings on consumer reports, which the industry had argued at the time was preempted by federal law. And in 2021, we prohibited hospitals from reporting certain medical debt to consumer reporting agencies. So this bill is really consistent with these past actions to safeguard consumers. I have provided an amendment to the committee based on feedback from 2 state agencies. The AG's office requested that we narrow the definition of medical debt, which we've done. And I'll note that actually the feedback from the AG's office does align with some of the requests for language changes that have been proposed by some of the opponents on the bill. And also the Maryland Health Services Cost Review Commission said we needed to make some conforming changes elsewhere in statute, which we've also included in the sponsor amendment. So thank you.
Good afternoon, Chair, members of the committee. For the record, my name is Marceline White. I'm Executive Director of Economic Action Maryland Fund. Economic Action works on economic rights, equity, and housing justice through research, education, advocacy, and direct service. Our direct service work touches clients in every county in the state. We're here in strong support of House Bill 1020 and thank the delegate for sponsoring the bill. Just to make a couple quick points. Medical debt is an issue in Maryland. We did a statewide poll in 2023 and found that 14% of Maryland voters had a medical bill that they or someone in their household was unable to pay. And 44% of medical debt that was unaffordable comes from outpatient visits. This bill also includes healthcare credit cards, but is narrow in terms of not including other kinds of credit cards. Credit, as you all know, is a critical tool for qualifying for mortgages, apartments, car loans, or other kinds of consumer loans. And this bill will make sure that these kinds of adverse reporting is not found on credit cards, as was passed recently by the Consumer Financial Protection Bureau. The Consumer Financial Protection Bureau does say that states can play a frontline role in protecting consumers from unscrupulous practices, and they can enhance laws that go further or reinforce federal protections. So we also have clarity from them that we can go further than what they've done. And there are ways to segregate and be clear about what debt is medical debt on healthcare credit cards. We think this is important to protect patients with medical debt from having their credit harmed and to build wealth at this critical time for working families. So for all of these reasons, we support House Bill 1020 and urge a favorable report. And I'm happy to take questions.
Hello, my name is William Steinwhittle. I'm the Deputy Advocacy Director for Homeownership Preservation at the Maryland Legal Aid Bureau, and I appreciate the committee and the chair for allowing me to testify on this bill. And Delegate Carr as well. We testify in strong support of this bill. Unlike other debts, medical debt is not the result of a voluntary decision, and it can be the result of what is generally is an accident or simple bad luck. I used to actually work in medical collections many years ago, and through that I saw that people had to pay thousands of dollars in debt simply for, an accident that happened on the job, especially in the farming industry, which is not covered by workman's compensation generally, and also just simple car accidents or even crime, the victims of crime, because the crime victims fund can be slow to process claims. And it is not fair for a person to have difficulty getting credit for housing and other reasons simply because of these issues. In addition, a lot of these debts are sold, especially the debts that are held by doctors' offices and smaller providers. And when they're sold, a lot of times the original the creditor that buys it does not do any research to see what the current status of the debt is. So there have been times where debts have been paid, and we have represented clients in bankruptcies, and we filed objections to claim where debts have been paid, and that wasn't reflected when the debt was sold. So. Because of those reasons, Maryland Legal Aid testifies in strong support of House Bill 1020, and I'm here to take any questions as well.
Thank you very much. Delegate Howard.
Thank you, Madam Vice Chair. Does this cover elective surgeries?
So the bill is for all types of medical debt.
We've seen a massive expansion in the type of surgeries that people can have and elect to have, so that would cover those surgeries.
All types of medical debt, yes.
Okay, thank you.
Delegate Adams.
Chair. Gentleman to the left, your organization that you represent, what again?
Maryland Legal Aid, we represent consumers in we represent consumers in civil and consumer and all kinds of civil law that qualify financially or over the age of 60.
So your testimony, I mean, I don't think it was tangent to the bill or it was a tangent to the bill, because you're talking about whether a debt should exist or not. In other words, most of your testimony was, look, I don't think that they should be obligated to pay that debt. The bill just says that the debt should not be reported in the credit reporting under the bill. So why are you testifying that a debt's not due? I mean, that's different than this credit reporting.
The point that I was trying to reach was that, well, when you purchase a car or when if you take out a credit card, it's generally a affirmative decision. But when your arm gets taken off by a compactor when you work at Purdue Farms, that's not a voluntary decision generally. No one's like, you know what, I think I'm going to get my arm taken off today. So that was the point I was trying to make, was that when a person voluntarily makes a decision.
With all due respect, the second scenario is an occupational injury under workers' compensation.
That isn't always necessarily the case, sir.
All right, you're missing the point. You are for the bill because you don't want the debt reported, or are you for the bill because you think it's a step toward the debt never being collected?
I'm for the bill because I don't want the debt to be reported on somebody's credit report.
Do you still think the debt should be collected?
In some circumstances, no. In some circumstances, yes. It depends if the person has a defense. It depends if they're eligible for free care. It depends if there was an insurance mistake. I mean, as a lawyer, it would depend on the facts of the situation. I can't speak for every situation, but yeah, if
the sponsor of the bill is putting a bill in because they're worried about future lending decisions that relate to medical debt, you're spending your time talking about whether a debt is still due and collectible. You're missing the point of the bill, because somewhere along the lines, maybe somebody like me considers a bill like this, but not on the basis that that was never collectible. And I would hope that this bill is not one step toward, okay, we're going to eliminate all medical debt because we don't think it's fair. That would be a bad political outcome.
Delegate Adams, and
Sure,
just to clarify,
absolutely, to the
the
sponsor.
bill does not relieve any patient of their obligations to pay for debt. It does not prohibit or prevent any healthcare providers or debt collectors from collecting on medical debts. It's simply about what information appears on the credit report.
Okay, and your purpose for the bill then is to make it easier for people to get on with life and not have to, okay.
That's exactly right, yes.
That's the limit of the bill.
That's the limit of the bill, and I have no intention of going further than
I
that in
wasn't
the
a
future.
big fan of the testimony down the line there. Thank you.
Delegate Howard.
Thank you. And just, I usually don't ask follow-ups, but so there's 6.1 million Marylanders. By 2030, there'll be about 29, almost 30% of them will be over 65. So I completely understand the premise of the bill. Would you be willing to entertain an amendment, a very detailed amendment that would carve out elective surgeries?
Well, on your first point, I'll just say I think we're going to actually hear from AARP in a moment. I think the issue is who decides what's an elective surgery. When we look at the models that other states have taken, they're saying it's all medical debt. The federal rulemaking that was finalized and now is on pause was all medical debt. It wasn't specific to certain types of medical debt.
Mm-hmm. But we would. We're the political body. We would decide.
How would a consumer reporting agency, though, make that decision about exactly which particular
We would outline
codes?
it in the law.
I think it'd be very hard to implement. I think it'd actually be unworkable from the consumer reporting agency's point of view. So I would say no, I would not consider that a friendly amendment.
Okay, thank you.
Any other questions? Seeing none. Thank you very much, Delegate Polakovich-Carr. We have more favorables calling on Franz Schneiderman, Byron Chung, Karen Morgan, and Michael Patty. Anyone can begin.
Thank you, Delegate Valderrama, committee members. My name's Franz Schneiderman. Thank you for the opportunity to address the bill. I work with a group called Consumer Auto Maryland. We're a nonprofit devoted to protecting Maryland consumers and Maryland drivers. And we strongly support HB 1020 because we think it provides some important protections for Maryland consumers who encounter medical debt. Studies have shown that this kind of medical debt is a very weak predictor of future financial behavior or other behavior, which is what credit reporting is supposed to be about. But it's also, until recently, through 2022, they were among the most common problems reported on consumer credit reports because it's so easy for people to encounter medical debt. These debts are not like other debts in that nobody really chooses to encounter medical debt. You don't have any real choice about the costs or much in the way of choice. And very often they are incurred as a result of one unfortunate illness or event. Statistics show that it has very little link to your future financial behavior, but the harm that it does to your credit rating can certainly have a serious effect on your life, not only your ability to get a mortgage, credit, but as we've talked about in this committee before, the amount you pay for insurance and other things. So it's really important that we protect consumers against this. As you may have heard, some of the federal consumer groups have worked on protections. Those are being rolled back now. In 2022, the national credit agencies enacted some protections that helped diminish the impact of these debts. I mean, with less regulatory pressure, I don't know that even those reforms will survive. So it's really important that the states step up and provide the kind of protections HB 1020 would provide. So I hope you'll give the bill a favorable report. Happy to take any questions. Thank you.
Good afternoon, Madam Chair, members of the committee. My name is Byron Chung, and I'm a student attorney with the Public Health Law Clinic at the Maryland School of Law, and I'm here to urge a favorable opinion on House Bill 1020. As you may have heard, medical debt affects many adults in the United States and is different from other types of debt because people do not often have a choice whether to take on medical expenses or not. The impact of medical debt is felt not just in dollars. Unpaid medical bills are reported the same as other types of debt on a standard consumer credit report. The presence of any medical debt, even if not in collection status, can severely reduce an individual's credit rating. House Bill 1020 would protect the creditworthiness of Marylanders by limiting what and how medical debt is reported to credit reporting agencies. I've seen firsthand how pervasive the effects medical debt can be. I worked in healthcare before law school, and I've had patients tell me that they want to pursue less effective treatments or have to give up their entire month's paycheck because of the cost of care. Marylanders have not been spared from the effects of medical debt. Between 2009 and 2018, over 145,000 lawsuits were filed in this state related to the collection of medical debt, leading to 3,200 bankruptcies and over 37,000 wage garnishments. Shockingly, the median amount of debt targeted in these lawsuits was only $944. As mentioned before, there have been some positive changes. In 2022, the largest national credit reporting agencies have announced that they will limit how medical debt is considered in credit reports. As a result, over 27 million people saw drastic improvements to their credit ratings. However, these changes are voluntary and can be withdrawn at any time. And as highlighted before, the CFPB is under assault, and how they can protect individuals has been severely curtailed. House Bill 1020 by itself will not solve the issue of medical debt, but it represents a timely and critical step for this assembly to protect patients from the outsized economic effects caused by medical debt for all Marylanders. For these reasons, we urge a favorable report. Thank you.
Good afternoon, Delegate Valderrama, members of the House Economic Matters Committee. My name is Karen Morgan. I'm here representing AARP Maryland. I'm a member of the Executive Council. AARP Maryland is one of the largest membership organizations in the state. We look out for over 800,000 people. Of course, those people were 50 and older, but their families too. And those families can be of any age. And when medical debt becomes an issue for a person who's age 50 or older, it becomes an issue not only for them, but for everyone in their circle, in their family. We found, AARP research has found that adults 50 and older are particularly affected by medical debt and the recording of that medical debt on their credit reports. So if a person is age 65 or older, we know that they qualify for Medicare, but we also know that Medicare covers only 80% of a hospital debt. So the other 20% has to come from the patient. That 20% can be a heck of a lot of money. I have a family member who had a hospital stay. It came up all of a sudden. And the 20% that she had to pay was staggering. And we found that 44% of people ages 50 to 64 and 22% of people ages 65 and older carry some sort of medical debt. It's become a cruel cliche to fret about the cost of health care in America. We think HB 1020 would alleviate some of that pain by just saying to consumer reporting agencies, you're not going to report that debt, and saying to hospitals and other health service agencies and providers, you're not going to report that debt. That debt still needs to be paid, but people don't need to be hamstrung while they're struggling with health issues. So we urge a favorable report on HB 1020. Thank you.
Great. Thank you, Madam Chair. Michael Patty here today on behalf of the Maryland Community Health System in support of House Bill 1020. We're a network of federally qualified health centers located across the state, and these FQHCs are vital for communities lacking access to health care. We primarily offer primary care dental services and behavioral health services. Our typical patient are low income and the vulnerable population who may face other significant hardships in life. FQHCs operate on a sliding fee scale, and then by preventing certain credit reporting, we're hopeful that this will help our patients, better manage their finances. We're committed to providing, comprehensive and affordable care regardless of a patient's ability to pay. This bill really does align with an FQHC's mission of patient-centered care that's not hindered by certain fear of financial consequences. And we would just ask for a favorable report on the bill. Thank you.
Thank you. Are there any questions for this panel? Seeing none. Thank you very much. Members will now move on to the unfavorable. We have Zachary Taylor, Lisa Jones, and Barry Glassman. Welcome, Barry.
Good afternoon, Madam Chair. I'm Zachary Taylor. I'm the Director of Government Relations for the Consumer Data Industry Association. Founded in 1906, we are the trade organization representing the consumer reporting industry, including the consumer reporting agencies that would be affected by this bill. We respectfully oppose the proposal HB 1020 for a handful of reasons, but first and foremost, this is preempted by the Federal Fair Credit Reporting Act. As I outlined in my comments I submitted to the committee, the Fair Credit Reporting Act regulates our member companies and what can go on a consumer report and what can be furnished to a consumer reporting agency. Medical debt is allowed to be included on a consumer report under the FCRA, and that information is allowed to be furnished to us. We certainly understand the concerns about medical debt and sympathize with some of the comments raised earlier. However, incomplete consumer reports are an incomplete tool for lenders and others to appropriately evaluate risk. Arbitrarily removing amounts owed from a consumer's report that are on there and have not already been removed by some of the actions we've taken can make them less reliable. When that happens, reports are less reliable and the ability of lenders to accurately price risk goes down. Certainly want to note as well that our companies have made some changes to how medical debt is reported. First of all, unpaid debts must be more than $500 in outstanding for more than 365 days before they can appear on a consumer report. Amounts that are reported less than that do not appear on a report. Amounts that are less than that have been removed from reports. This is an important change that has removed a substantial portion of medical debts from consumer reports, as well as providing additional time for consumers to navigate issues between their insurers, between providers, and to establish payment plans. I want to just point out again that it is inconsistent with the Federal Fair Credit Reporting Act, which has expressed preemption over provisions that are inconsistent or otherwise conflict with it. We do know the CFPB has issued its advisory opinion, but that was issued outside the course of rules. Thank you for your time. Happy to take any questions.
Thank you, Madam Chair. Barry Glassman on behalf of Lisa Jones and the PRA group. She's held up in another committee. PRA is a publicly traded company that, through its subsidiaries, purchases portfolios of consumer receivables from major banks. PRA partners with individuals to repay their obligation, working towards financial recovery. PRA appreciates the sponsor's efforts to assist consumers undergoing difficult times due to expensive medical bills from hospitals and healthcare service providers. Our really only issue with the bill is the definition of medical debt. The medical debt definition in the federal rule really ties it to just those expenses, debts owed to a primary business providing medical service, products, devices, or to a person's agent or signees. The bill as drafted includes credit cards. That is not in the federal definition, the federal rule. And since there are 3 or 4 medical debt bills working their way through a couple of the other legislative committees, we feel that there should be a consistent definition that matches the federal definition throughout the code, just to clarify exactly what medical debt is. Otherwise, we appreciate the sponsor's efforts to protect those folks on their credit reports.
Thank you. Delegate Charkoudian.
Mr. Chair, my question is for this gentleman over here. I'm just wondering if you've had a chance to read the Attorney General's opinion on this, which goes through considerable case law and analysis and concludes that this is not preempted.
I have not had the chance to review that letter.
Okay, well, we can make sure that you get a copy, and generally in the General Assembly, we trust the Attorney General to tell us rather than the industry to tell us when something is preempted. So we'll make sure you get a copy of that, though. Thanks.
Any other questions? Seeing none, thank you very much.
Thank you.
This concludes the bill hearing on House Bill 1020. We're going to see if the chairman is ready yet, and if not. So next, we're doing the chairman's bill, House Bill 956.
You all set? Okay. Good afternoon, Madam Chair and members of the esteemed Economic Matters Committee. My name is Sharon Lanier. I serve as Legislative Director for Chairman Wilson, and I'm here to present and testify in behalf of House Bill 956. This bill ensures Maryland takes a proactive approach to AI policy, balancing innovation, consumer protection, and fairness as the technology rapidly evolves. AI, as federally defined, includes machine-based systems that make predictions, while generative AI expands its capability to creating images, text, code, and audio. While these advancements offer significant potential, they also pose risks, particularly in consumer-facing applications. House Bill 956 establishes the work group on artificial intelligence implementation to continually monitor AI regulations and their impact on consumers and businesses, study private sector AI use and identify best practices, review enforcement mechanisms under the Attorney General's Office of Consumer Protection, and develop policy recommendations to ensure adaptable and responsible AI governance. AI consumer protection policies are complex, so we took proactive steps to address these potential challenges before they arise in Maryland. By examining issues faced in model states like Colorado, we can craft a balanced approach that promotes responsible AI use while minimizing unintended consequences. Some of the issues we saw in states like Colorado were ambiguous definitions, where unclear terms created compliance uncertainty for consumers, developers, and deployers. An example being, if a Maryland tech firm develops an AI tool to assist with tenant screening, but vague legal definitions make it unclear whether the algorithm complies with fair housing and anti-discrimination laws, the uncertainty puts both landlords and developers at a risk of legal exposure, highlighting the need for clear, standardized guidelines. Other issues include burdens on small businesses involving the overregulation of AI, disproportionately impacting startups. A real-world example could be a Baltimore-based AI startup wants to launch an automated customer service tool, but struggles to afford legal guidance to navigate Maryland's evolving AI regulations. Moreover, without clear, scalable compliance pathways, small businesses may face higher barriers to entry than larger tech companies with dedicated legal teams. And then transparency versus trade secrets and balancing disclosure with proprietary protections. Of course, while transparency is critical for consumer trust, overly broad disclosure requirements could force the companies to reveal proprietary AI details that could potentially expose vulnerabilities that bad actors could exploit. And lastly, enforcement gaps in ensuring effective oversight without stifling progress. Without well-defined oversight systems, businesses and regulators struggle to determine appropriate corrective actions, leading to inconsistent enforcement and uncertainty in compliance. House Bill 956 positions Maryland at the forefront of AI governance by reinforcing fairness, innovation, privacy, security, reliability, and accountability. The work group will develop recommendations by July 1st, 2026, shaping policies that protect consumers, foster innovation, and provide clear regulatory guidance for responsible AI development. I request a favorable report. Thank you.
Thank you, Charon. Is that Delegate Weigel?
Thank you, Madam Chair. So the fiscal note says it's $100,000 for the study to hire additional staff. Do you know if that's still the case?
I do believe that is correct, then, Delegate Weigel.
All right, thank you.
Of course.
Any other questions? Seeing none, thank you very much, Charon. We'll move on to Kaylee Locklear, Maryland Retailers Association.
Good afternoon, Madam Chair and honorable members of the House Economic Matters Committee. For the record, Kaylee Locklear here on behalf of the Maryland Retailers Alliance. We are in support of this legislation. We think the opportunity to bring stakeholders together on this important issue before jumping into legislation is really important. And I wanted to add just a perspective from small businesses here, many of which are actually relying on AI to compete now. So for instance, small businesses selling products online can and do use generative AI to quickly create compelling product pages, which saves them hours of time and money. So that's just one example. But that's why we're really pleased to see in the bill that there are representatives from the e-commerce industry, which will be included, but I would implore the committee to think about a small business e-commerce perspective when appointing that. So we urge a favorable report, and I'll stop there. Thank you.
Seeing no questions, thank you very much.
Thank you.
We have a virtual for favorable, Margaret Durkin.
Good afternoon, Madam Chair and members of the committee. My name is Margaret Durkin, and I'm the Mid-Atlantic Executive Director with TechNet. Thank you for allowing me the opportunity to speak today on House Bill 956. We too support this bill as we believe that it will allow for small businesses to access the benefits of AI technology while allowing their participation on a task force. And task forces establish lines of communication, provide industry expertise on AI, and allow for the development of consensus frameworks on responsible AI regulations. Thank you for your work on this issue.
Seeing no questions, thank you very much, Ms. Durkin. We'll now move on to favorable with amendments. We have Marceline White, John Fiastro, and Evan Richards.
Good afternoon, Madam Chair, members of the Economic Matters Committee. My name is John Fiastro. I'm here representing my client, the Cybersecurity Association. The Cybersecurity Association has taken a favorable with amendment position on this bill. The Cybersecurity Association is asking to have a member of the association added to the work group enumerated in the bill. You'll note, as you look at the membership, there are representatives from the Maryland Tech Council, e-commerce, biotech, real estate, healthcare, and so on. It is appropriate, given the current climate, to have a cybersecurity professional on the work group. AI cyber attacks are on the rise. Automated phishing, AI-powered malware, all in the current environment. So as the work group considers consumer protections, cybersecurity should be considered as well. And for that reason, we ask this committee for a favorable report with an amendment, including a member of the Cybersecurity Association. Thank you, Madam Chair.
Madam Chair, members of the committee, again, Evan Richards from the Maryland Bankers Association. Here favorable with amendment to add representatives of the financial services industry to this work group. As I disclosed in the previous bill hearing, that AI is something that's being used by most banks across the country. Whether it be through fraud detection, during their lending process. And again, while it's heavily regulated, we just want to make sure that the voices of the financial services industry are heard in this work group to avoid any potential redundancies or any conflicts with the laws and regulations of our state and federal banking regulators.
Thank you very much. Seeing no questions, that ends the bill hearings on House Bill 956. We'll now move on to House Bill 1018, Delegate Pruski. Do you have a panel?
I do. Can I bring that forward, please, Madam?
Yes.
Good afternoon. Delegate Andrew Pruski here on HB 1018. 1018 is financial institutions, conventional home mortgage loans, assumption and required disclosures. This bill would require certain entities, such as banking institutions, credit unions, and mortgage companies, to include a certain provision in the home mortgage loans authorizing certain borrower to purchase the property interest of another borrower and decree an absolute divorce case under certain circumstances. It also requires entities to disclose certain provisions in writing to a loan applicant prior to the completion of the loan application. In summary, this bill will require all home loans in Maryland that are not ready assumable in case of divorce, knowing the party assumed loan qualifies for that mortgage loan to be assumable. Why is this bill important? I know she's not testifying today, but I'd ask Kelly Seeley to stand up. She's in the back. Thank you. Kelly's an Anne Arundel County resident who brought this forward as an advocate, and I'm going to just tell you a little story today. I want you to imagine that you live in Maryland and you want an effort to stay in your home and you're going through a divorce. Imagine that you attempt to call the mortgage or loan industry and you've asked to assume that loan to keep your home. And they keep telling you no. You call 3, 4, maybe the 5th time, and then all of a sudden, after advocating over and over again, you're informed that you can assume the loan. This is a problem and it frequently happens. While you're still in the process of assuming the loan, you're trying to keep for your family and children. And obviously you want to stay in your home because that's where your roots in your community and your schools are. So let me tell you about current law. Here's the background. Under existing law, an assumable mortgage is a home loan that can be transferred from original borrower to the next homeowner. The interest rate and payment periods stay the same. Essentially, only the name on the mortgage documentation changes. Everything else remains the same if the mortgage is assumed versus if a mortgage is refinanced, which obviously can be more costly, and especially for those of you that have refinanced your home anytime soon, you probably know what I'm talking about. Refinancing would result in a new loan with new terms, new interest rates, and new repayment period. The primary advantage of assuming a loan could be to maintain a comparatively low interest rate, which can save you hundreds, possibly thousands of dollars per month per the annuity of the loan, and so on. This could mean the difference for people to stay in their home or being uprooted during a tumultuous time in their life. Several home loan types are already assumable. For those of you, and some of you in this room may have these type of loans, FHA, VA, or USDA loans are assumable. Most conventional home loans, though, a type of mortgage that is not backed by the government, are not assumable in most cases. Conventional mortgages fall into 2 categories, conforming and non-conforming loans. In cases of divorce, conforming conventional loans cannot be assumed. Non-conforming conventional loans cannot be consumed. Conforming loans follow the guidelines set by Fannie Mae and Freddie Mac. Obviously, you've heard of those. There are 2 government-sponsored enterprises that provide money for the U.S. housing market. The best known rule has to do with the size of the loan. Just to give you an idea, though, in 2025, there's a conforming loan limit. That conforming loan limit, and this includes Anne Arundel County, is $806,500, so $806,500. But there are some areas in Maryland, which are Calvert, Charles, Frederick, Montgomery, and Prince George's, have a higher limit, and that is $1,149,825. Many non-conforming loans you refer to as jumbo loans, which are not for home buyers who need to borrow an amount that's higher than their conforming limit. Notably, is the case here that was brought to me, Anne Arundel County refers to a lower threshold and obviously has some higher living costs, and it impacts especially the assumability in cases of divorce. This bill helps to keep families in their home, and I believe also generally puts everyone on the same page. On the panel today, you will hear from 2 attorneys and other folks. I want to highly point out a few things because fiscal notes do matter. The fiscal summary state effect, this bill does not materially affect state operations or finances. Local effect is none. And of course, if there's a small business effect, it's potentially minimal. For these reasons, I asked for a request for a favorable report on HB 1018, and I thank you for your time.
Hi, my name is William Steinwittle. I'm the Deputy Advocacy Director for Homeownership Preservation at the Maryland Legal Aid Bureau, and I thank the Chair and Delegate Brzezinski for allowing me to testify on this issue. I apologize for mispronouncing your name. I just wanted to add so we represent a lot of homeowners that are in foreclosure, and we represent them in order to allow them to keep their home. And we see this as a constant issue, the assumption problem. And I just wanted to to tell two stories. The first one is that we represented a homeowner who was in an abusive relationship and received a divorce and received full possession of the home in the divorce. However, because her ex-husband was still on the loan, she was offered 2 modifications and her ex-husband refused to sign them. And she couldn't get the modification because he refused to sign it. So we eventually had to litigate the case as a contempt in state court and finally get basically a court order ordering him to comply with the loan modification process, allowing this to sign the documents. We believe that this bill would go a long way towards preventing that necessity. In addition, we assisted a homeowner, and she did receive a loan modification, and we didn't run into the particular problem that was described in the previous case. However, she had to make a good faith payment to get the loan modification. Unfortunately, the mortgage company refused to allow her to even call in a payment because she was not on the loan, even though she had assumed the property. So the only way she could pay was to send it through the mail. And as we all know, that can, especially when you're talking about over $1,000, that can be, very concerning and very risky. So for these reasons, we testify in strong support of House Bill 1018.
Chair Wilson, Vice Chair Crosby, and members of the committee, thank you. My name is Margot Cook, and I serve as President, Wealth and Engagement Planning at Rothschild Capital Partners. I'm a certified financial planning professional and a certified divorce financial analyst. I applaud you for considering HB 1018 to enable divorcing individuals the ability to assume their mortgage and stay in their homes, offering critical stability for families. Over the past several years, interest rates have risen dramatically. Many divorcing homeowners currently hold low interest rate mortgages, and refinancing at today's higher rates would impose significant financial hardship. Preserving these existing terms can be the difference between maintaining home ownership or being displaced. For parents, the impact is even greater, as keeping the family home often means preserving stability for their children, allowing them to stay in the same school district, maintain social networks, and remain in a familiar and supportive environment. In my professional role, I frequently guide divorcing individuals through complex financial transitions in Maryland. While I do not suggest that all lenders engage in opportunistic practices, market conditions may create a financial incentive for lenders to prefer refinancing over mortgage assumptions, placing borrowers in higher interest rate loans and/or requiring large fees to assume a mortgage. These fees appear to exceed standard administration costs, sometimes in the tens of thousands of dollars. Clients have directly reported these experiences to me. This bill would help address these challenges. A key provision of this bill is its retroactive application, ensuring that borrowers with existing conventional mortgages can benefit from the law, rather than limiting relief only to future borrowers. Without this retroactive effect, the bill would fail to protect those most affected, like Kelly, individuals currently navigating divorce with low interest rate mortgages who are struggling to maintain home ownership in unfavorable market conditions like higher interest rates. In my view, the retroactive application of this bill does not create additional financial risk for lenders because this does not require lenders to approve unqualified applicants. Financial institutions would retain full discretion to deny an assumption if the borrower does not meet the necessary financial criteria. They also retain discretion to resell the mortgage. Thank you for your consideration.
Good afternoon. My name is Richard Green. Thank you to the committee for allowing the Maryland Mortgage Bankers and Brokers Association to offer support with an amendment regarding House Bill 1018. We absolutely support the bill and the spirit of what is trying to be accomplished. However, it is the retroactive application that is of concern. When a borrower enters into the transaction, they signed a mortgage note. That document is generally in Maryland a Fannie Mae uniform instrument, been used for decades. But it clearly spells out the obligations under the terms of that note and that it is in fact due and payable upon transfer of title. There is a strong argument, given that contractual obligation, that the retroactive effect of the bill would be unconstitutional and an impairment of contract rights. So that is a real concern from day one. Additionally, the proposed regulation requires an effective date 6 months from passage, and that poses significant issues for the mortgage industry. They would have to craft a new mortgage note, new mortgage disclosures. Lenders would have to review and establish all sorts of training and computer policies, et cetera, to make that happen. So we would look for a longer period of implementation. California recently passed a similar type bill. However, they put a 2-year time frame on getting it started, which gives the industry time, and it's effective. You can't go backwards, okay? And it's of note that Fannie Mae and Freddie Mac currently do allow assumptions. However, it is not retroactive in nature. There was also a comment made that FHA and VA loans are already assumable, and in fact, they are assumable.
Could you wrap it up, sir?
That was in the documents from day one. So accordingly, the Maryland mortgage bankers are in support of the amendment.
Sir, would you kindly wrap it up?
Yeah,
Thank you.
we are in support of the of the legislation with the amendments as mentioned.
Thank you kindly.
Thank you.
Delegate Ahrens.
Delegate Prusky, I'm sorry.
Yes, sir.
You know, when I looked at the bill, I just skimmed through all the testimony and stuff like that, and it seems difficult to me because this is how people make money. They sell a home, the banks make money, and all these institutions, that's how they make money. When you're looking at some of the interest rates that are out there today, there's some 3% interest rates and what have you, and some of them aren't term, some of them forever. Who's paying for this? Because there's a lot of money being left on the table here. If I sell my house to this delegate here and I have a 3% loan and the rates are now 12 or 6%, there's a lot of money left on the table. Who pays for that?
Okay, remember, this is a conventional mortgage that somebody has, somebody was married, spouse, or somebody else takes on that loan. They want to keep that loan, so the other party is no longer involved. All they're doing is changing the name, and they're continuing that loan.
It's purely for that. There's no other, it's not going anywhere else. Because other companies, like we were stating, you said it, they are already doing it for regular loans and approving that stuff. But this is just for me.
Correct.
Okay, thanks.
Quick question. Would this apply if someone died?
I'm unsure about that, because I know this mentions divorce decree, so I'm unsure if that would be included, because if you look at the purpose and written part of the bill, it doesn't mention that.
There already are some federal protections for the heirs to property to allow them to assume a mortgage if a death certificate and/or a will is provided. So there are protections for that already. From my experience, it tends to be less contentious, especially if you have the death certificate.
Any other questions? Seeing none, thank you very much.
Thank you, Madam Chair.
We'll now move on to favorable with amendment. We have Evan Richards and Bob Enton.
So I'll start with some good news. Dr. No isn't here, so you just have me today. The Maryland Bankers Association, favorable with amendments on House Bill 1018. We do appreciate the House and Senate sponsors bringing this issue to our attention a few months ago. Again, Section 1 of the bill, we don't have a problem with. It's the retroactivity piece of this. I'll echo the comments of the mortgage bankers. Again, typically when you're adjusting the terms of these mortgages, you're going to have to notify the mortgagor. It's not quite clear exactly how that's done, whether that's done through the originator. And that's, if you use the originator for an example, you have these mortgage loans that are bought and sold on the secondary market all the time, meaning that if you have a existing mortgage that's been out there for 25 years, this thing has probably exchanged hands 5 or 6 times by now. So we do have some issues with that. But again, the biggest concern being, does changing the terms of a binding legal document affect the sale of any of these mortgages on the secondary market? Especially for those private investors who decide they only want to purchase packages of loans that don't have this assumption in the loan document. Is there any sort of risk with adding that assumption in there? Is to open anybody up to litigation? That's without knowing, these packages become less valuable. And with the way they're sold in the secondary market, ultimately any money that's made does end up going back to the lender, who then in return uses that money to make additional mortgage loans. So again, we do have concerns with the retroactivity piece, but we are willing to continue conversations with the sponsor and interested parties to see if we come to a resolution.
Thank you, Mr. Richards. Delegate Howard.
Aren't they just buying the mortgage? I mean, you're just swapping the book, right? So you're buying, Bank of America owns a 3% mortgage on a house, and a couple gets divorced, and he, buys the wife out, and he now owns the 3% mortgage, and the mortgage swap happens, and next thing you know, PNC owns it, but it's 3% mortgage. I don't understand
So they may own the servicing rights, but the actual mortgage itself still may be held by some sort of private investor.
The actual what?
The mortgage itself may be held by some private investor.
Yeah, like a bank, right?
Well, so yes, a bank would be an example of that.
So that you're just buying a whole book of loans. I mean, they're going in there and they're buying, I don't know, 500, 1,000, a book of loans, and 3% mortgage is 3% mortgage, or a 6% mortgage is 6% mortgage, right?
Right.
And how's it going to affect the swap, basically?
Well, because when you're looking at the rate of return that these mortgages have, if you do adjust those loan terms, let's say you do refinance now,
right?
You're expecting a certain amount of return, as a holder of the mortgage.
But I don't think the bill's talking about that at all. I think it's just talking about switching party, right? Yeah. Swapping the party. I mean, it's from husband to wife, wife to husband, whatever. Yeah. Whoever gets the divorce. The mortgage is still the mortgage. It's still concrete. It's still termed. It's still, it's still enforceable. It's still, based on the current set of parameters. It's just a matter of who owns the paper at that point. And they're basically just buying the paper, right? They're buying the mortgage at 3%, whether the husband or the wife owns it, whether they're married, not married, doesn't matter. They're just buying in a big book, of 1,000, 500, 10,000, mortgages. So I don't understand how it would negatively affect people going in, the retroactive piece of it. I don't understand how we're drawing a line from A to B that it would negatively affect people going in and potentially not buying service rights to the loan or the loans as a whole.
And so I'll have to go back to our membership, try to get some more explanation. I'll send it away.
Right. Delegate Ahrens.
This sounds like something too good to be true to me, so that's why I'm asking questions. How do you make your money? Because there's work to be done here. What is the charge to do this? Because this is not a simple transaction. This is, if you've sold that loan, you got a whole lot of things you got to jump through to do that. So there's got to be some downside to this, because it is too good to be true the way you're saying it. So the bank's got to charge something for this. And do you have any idea what that's going to entail?
You're looking at similar charges to what you would have, when you're closing on a loan. I can get more information as to what, a typical charge for an assumption is.
So you're saying that this would be just like me applying for a loan? I'm just going to have to maybe get an appraisal. I'm going to have to walk out and do a couple things, comps and all that other stuff.
Something similar in nature, yes.
Similar to that. And there's no additional fees because you are trading a loan that you could make some money on, potentially. Right. How is that handled today?
Yeah, that I'm not sure.
Okay, it's like going through a whole refinance then. Right. Is what you're saying. Okay, thank you very much. I like the idea, by the way.
Any other questions? Seeing none, thank you very much, Mr. Richards. That concludes the hearing on House Bill 1018. We'll now move on to House Bill 917. Delegate Ampry.
I'm gonna keep this short and sweet. I think I gave you all my time yesterday. For the record, Delegate Marlon Ampry here in support of House Bill 917. It's a really simple bill that I was in talks with the Maryland State Bar Association Business Law Section, and we talked and they asked me to bring this bill forward. What it essentially does is this changes some of the fees, one of the fees for Form D filings here in Maryland. Currently, our Form D filings are $100 for an exemption Form D filing, which is essentially a securities filing. In comparison to other states, New Jersey's charging $750, some states are $350, some states are $400. We're only $100. Our neighboring states are about $250. So this just brings us to the $250 mark to be right in line with the rest of the other states that are nearby. Speaking with the Bar Association, we've had conversations with their clients. They said this will really have no effect on business decisions or moves. So it's simply just a change in the fee amount. And if you look at the fiscal note, this is one of those bills that brings in a little bit more money. So, you know, it's a nice little relief during this period. So also I put a letter on your desk from the Maryland State Bar Association, which the original language of the bill included a fee for the amendment that we added that other states have. We went ahead and amended the bill to take that out. So this current bill meets the request of the Maryland State Bar Business Association. And with that said, I ask for a favorable report on House Bill 917.
Any questions? Seeing none, thank you very much. That concludes the bill hearing on House Bill 917. And our last bill of the day, House Bill 979, Delegate Andre Johnson.
Madam Chair, can I bring my panel? Good afternoon, Chair, members of the committee, Delegate Johnson, and here in support of HB 979. This bill is it's an addition to the bill that was passed last year from this committee. There was an agreement from the self-storage industry and the consumer protection division of the Attorney General's office last year, and that this portion of that came in very late, so we couldn't amend the bill last year. The governor signed the bill last year with the intentions of us coming back this year and putting in this amendment to add to this bill. So essentially what it does is this is a pro-consumer bill. What happens is that we've had to add an addition to a delinquency notice. So there was a 10-day notice that was given out to folks that had self-storage facilities, and now what happens is that there's a 10-day notice, and now after 10 days, if that person doesn't respond in 5 days, then another notice has to go out to that person, and it has to go out via verified mail. So with that, I'll turn it over to my panel, and I ask for a favorable report.
Thank you, members of the House Economic Matters Committee. For the record, Bruce Periano here on behalf of the Maryland self-storage industry. First of all, I want to thank Delegate Johnson for introducing this legislation. Some of you that were on this committee last year should recall the bill did pass, as the delegate indicated, inadvertently, not intentionally. This language was left off the bill when it went back over to the Senate. It was an agreement done by my client and the Consumer Protection Division. Mr. Sakamoto Wangle is here to verify that, and I also have a written confirmation of that. The language in the bill is exactly what was agreed upon by the industry and the Attorney General's office. And a promise made is a promise kept, and that's what this bill's all about. It's technical. It's I would urge a favorable consideration so that the industry can keep its promise and, as the delegate indicated, give further consumer protection notice process in the case of a failure to pay rent to storage facilities due. Thank you very much.
Seeing no questions, thank you very much.
Thank
That
you.
concludes the bill hearings on 979 and the bill hearings for the day. Members, we do have an event this evening, and note it says 5:30, so just letting you know what time they put. And we also have voting. Crap. We have voting up. When the chairman comes out, we have a,
Yeah. And I'll be here for that. And there's no opposition from the control's office. Okay.